Hello everybody, hopefully you can
quietly come upstairs to my bedroom, please.
hear me and my husband telling my children to come upstairs. I have an Alexa somewhere in my room. I'll try and find it and turn it off. Can everyone hear me okay? I'm just trying to set up my screens and juggle lots of different things on lots of... Can you hear me, Justine? Can you just put a thumbs up because I can see you? Hey. Thank you very much. Excellent, and thank you, Hannah. I'm going to turn this off so that we don't get announcements. I will warn you that my children will come in at about 7:30. Well, 3 of them will come in at about 7:30 to say goodnight. Hopefully without any arguing, on the basis that my husband is going out shortly, so I'm in full parental charge. All right. So I just need to make sure I'm letting everybody in as well. Hello. There's a fox cub. Okay. I can't go yet. It's okay. Take a picture. Okay, you take a picture of the fox cub for me. Good girl. All right, so we have a fox cub in our garden.
Guess what? There's a fox cub sleeping.
A fox cub sleeping. Okay, that's good. Where is it?
It's down the bottom.
At the bottom of the garden.
Yeah.
Okay. Right, what's all going on in Ipswich? Okay, so we've got around about 470 people signed up to join us today, but I suspect that many will be joining us a little bit later. I need to see if I can work out what you can all see. Hopefully you can see the slides that I'm just going to be going through this afternoon or this evening rather than anything else. Let's see what else I need up on my screen. Who's that? Oh wow, that's cool. That's the Bobos. Ah. Oh, go back. Okay, good. Off you go. All right, I need to make sure I've got the chat somewhere as well, so I can keep that eye on that. Okay, thank you, Heather. We have had some problems with the mismatch between Eventbrite timing and also Zoom timing. I thought I'd corrected it, but evidently we haven't. Hopefully people should be able to join through the Eventbrite link, which is quite difficult to say when you're rushing through it. All being well, the event's being recorded anyway, so everyone will be able to catch up. I suspect people are joining through the link that I've sent out now with the meeting room details and password. So I'll just try and get as many people in as we can now before I start, because I think I'm the only one who's on today. So we'll get a few more people in before we join. obviously, in the meantime, if you do have any questions, do let me know. You can use the chat. Hopefully there'll be some time towards the end where we can sort of open things up to people to come on and sort of verbally ask any questions or have a discussion, and if people are brave enough. Otherwise we can just do it through the chat function. So if you do have any questions that you would like me to try and answer, then please do ask away. We have put another event into the diary, which I'll give you the details for at the end, which is around issues returning to work. I think that's 17th of May from the top of my memory. And so I might take the easy way out and pass any questions around that across to that event if I may. But if I can't answer them, obviously I will do my best. So we're up to 30 now. People are joining thick and fast, I think, now. So they probably have the link. In the meantime, as we're just waiting, for anyone who joined slightly early, you will have understood that we have a fox cub in our garden. So I don't know whether you can see me or not, but if I hold that up, that's our beautiful little fox cub who is fast asleep in the garden. No doubt there's a mummy and a daddy fox cub somewhere, but okay. So, just try and work out and make sure I've got everything in the right places so that we can do this as well as we can across two screens. I've just got a few messages. I think people are struggling to get in, so if you just bear with me again. Okay. I'll just give it a couple more minutes and then I'll get started. Yeah, goodness, I wonder if I can change the Eventbrite setting. Just give me a second, let me see if I can get into Eventbrite. I'm blaming Zoom and it might be Eventbrite that's the problem. 7 o'clock BST. I think that's now, isn't it? We're in British summertime. Right, can I change the time? Start time. Yeah, we are in GMT +1, aren't we? This is me thinking out loud. Where have I gone? Too many tabs open in lots of different ways. Let's see. Paul there. I've got you there. Admit all. Okay, well, we're up to 60, so I will get started, and I'll apologise to everybody for the confusion about the start time. We've had a blissful period of however long it is where the times have all matched up within Eventbrite and Zoom and across the time zones and so forth, but we've moved into British summertime, and that seems to have caused no end of problems, so I apologise for that. What we'll do in future for the events is just make sure we send out the Zoom link, which seems to avoid the confusion, and make sure that the start times are there. So as I say, I do apologise. We will send out a recording as well, as I said, so we'll make sure that goes out as soon as we can, and that will be posted to YouTube as well. So welcome everybody on this relatively nice summer's, in inverted commas, evening. My name is Julie Temple, who I'm sure most of you will know. I am the co-chair of the Essex and Ipswich group, and they've very kindly invited me as a employment law solicitor and head of the employment team at Birkett Long to prepare and present this update tonight on employment law and HR. I'm going to try not to cover too much insofar as the lockdown and the reopening of lockdown is concerned. I will briefly touch on furlough, but also, as I mentioned a little while ago, we are doing a return to the workplace event. So that's going to be mid-May, and we'll come on to the details for that. If you would like to come along to that, you've got any questions that you would like to ask in relation to that, I'll do my very best to answer them, but I might carry the question over if I may. Okay, so let's get started. I'm gonna, if I pause and interrupt, it's just because I'm monitoring the admissions of people, and I'm just trying to make sure we don't let in any nefarious people who shouldn't be joining and might disrupt things. So I'm just going to whistle through where we are in terms of sort of changes that have been going on, things to be thinking about, legislation, so on and so forth. And I'm hoping to spend most of today looking at the case law. Diane, you have said that there is no sound. I'm not sure if anybody else is hearing me. Sharon, you can hear me, which is great, so thank you for that. Diane, if you just test your audio settings, hopefully that might resolve things, but it seems that everybody else can hear me, for better or for worse for them. Okay, perhaps if you go out and come back in again, Diane, that might resolve your problem. Now, if there's any problems furthermore, Diane, just let me know. But I think everyone else is hearing me loud and clear. It's going to be one of those nights, I think. Okay, so gender pay gap. Something we didn't have to worry about last year as we went into the pandemic. The deadlines were removed for the need for gender pay gap reporting. So if you are having to do gender pay gap reporting, you will know it's for employers of 250 or more employees. And there's a whole host of things that you will need to do and report on. The good news, the dates having already passed in any event, are that if you have not done your gender pay gap reporting for this year, on the basis of your head count for last year, 31st of March 2020 if you are public sector, 5th of April 2020 if you are private sector, the so-called snapshot dates, then you should have reported by the 30th of March of this year or by the 4th of April of this year, depending. Those dates have been extended because of the pandemic, and you, private or public sector, have until the 5th of October of this year to post your gender pay gap reports to the government website, and also to make sure that they are in an accessible place on your own websites. So as I say, not something that all of you will need to worry about, but if you are in the private or public sector and you have 250 or more employees as at the 31st of March or the 5th of April, and that's an annual recurring thing for you to check, then you will have to do your reports usually by the 30th of March the following year or the 4th of April the following year. But in this case, for the year 2020, it's going to be the 5th of October. So, you know, hopefully you've already done them. If you haven't, then you've got a little bit more breathing space. Now, as always, from the 1st of April, the national minimum wage rates have gone up. We have the apprenticeship rate, the 16 to 17 years, 18 to 20, 21 to 24. Sorry, I've noticed there's a typo there. So it's 21 to 23 in terms of the third to last row, and 23 plus, and then the accommodation rate offset, all listed there on the screens. The bits in brackets are the previous years. So Sharon, you've put me on the spot in terms of the UK-based employees of 250, and I know precisely why you've asked me. I will carry that over if I may, and I'll drop you an email on that in terms of the gender pay gap reporting. Off the top of my head, it is UK-based employees only, but I know my instinct isn't always correct on that. It's been a little while since I've had to look at the gender pay gap reporting. So that's obviously the position in terms of national minimum and living wage. If you haven't already reviewed your rates and rate of pay for individuals, then clearly it's something that you will need to do quite quickly, and that, as I say, is from the 1st of April. Next we have family friendly sick pay and the usual compensation increases. Family friendly and sick pay are from the 4th of April. I never quite understand why we have different dates for the national minimum wage and these sorts of things, and then also the increases to the compensation, but I'm sure there's method in the madness somewhere. I do apologise, Ola, that you've been trying to log in. As I've just explained, there's been a slight discrepancy between Eventbrite and Zoom not talking to each other, and I think the confusion is being caused by us moving to British summertime. I will make sure that in future the events go out with the Zoom link as well in advance, so that we can hopefully avoid this confusion.
Thank you.
Okay, thank you. In terms of, as I say, we've got the family friendly increases, and then also compensation increases, the usual annual increases for weekly pay for the purposes of calculating statutory redundancy and any basic award if you have the misfortune of being in an employment tribunal and an individual against the business having been successful, and also the cap on the compensation award. So if you're unfair dismissal, then the cap has gone up to 89,493 from 88,519. And I will do my usual gripe of not being quite sure why we can't do that in round figures and then being much more easily recalled. I do have, quite genuinely, I have a list of things that I'll show you on my desk next to me, so that I have them readily to hand. Vento bands have also gone up. I haven't put them on the slide, but the Vento bands, so the awards for injury to feelings, have gone up to 45,600 or above, from 45 for the sort of in exceptional cases. The top band is 27,400 to 45,600. The middle 9,100 to 27,400, and the lower 900 to 9,100. And as I say, I do genuinely have a sheet of A4 on my desk, which looks very much like you have on the screen there, which is just a useful reminder for me and anybody else who has them. And if you would like a copy of that for your desk, we do issue it on an annual basis, and it has on the flip side, the sort of calculator for redundancy payments if you ever need it. So if you'd like a copy of that, just drop your details in the chat, or fill in the survey for the event at the end, and we can make sure that they wing their way across to you. They are really useful cross-reference if you are ever having to look at details and calculations and things. Okay, so moving on from sort of the sort of more mundane bits and pieces, if I can put it like that, we'll have a quick look at some of the other things that have changed of late. And this one had actually passed me by. I will own up to not having noticed this one go through, not that we've calculated anything incorrectly for anybody. But post-employment notice pay is the bane of a number of people's lives, mostly employment lawyers and accountants, I suspect. 2018, I think it came in. It's a means of ensuring that HMRC get the correct proportion of tax. And I'm sure many of you will have been familiar with the approach of paying individuals in lieu of notice on termination. And if there was no contractual right to do so, then there was the ability to pay the notice pay gross, which obviously was in the interest of the employee and quite often in the interest of the employer, because it was more financially beneficial and you were able to get an agreement perhaps at a lower cost. As I say, HMRC realised this practice and determined that notice pay paid in lieu should be taxed, and we have this two-pronged approach. We have a basic formula for calculating post-employment notice pay, where notice is expressed in months, and a more complicated standard formula where the notice pay is calculated in other than months. And we, from the 6th of April of this year, have been able to use the number of days in the previous pay period before the termination takes effect of 30.42, whereas previously it was the actual number of days within each month, which then meant that the calculation differed, particularly if you were in February. So if you are in a position of having to calculate it, or you're instructing your solicitors, or you are asking your accountants or payroll, just make sure that, well, you can use that figure. You don't have to. It's not obligatory, but you have the ability to use that figure, and it may or may not be financially beneficial depending on the circumstances. I tend to take the approach of referring it on to payroll or an accountant, because 2 + 2 in my head doesn't always equal 4, I'll be honest, and my children will tell you they never ask me about maths questions from school. So that's post-employment notice pay, and as I say, that's been in place since the 6th of April of this year. Now, moving on to something else that came in from the 6th of April, IR35 and the off-payroll working rules. These did finally come in the 6th of April this year, having been postponed from the 6th of April 2020. In very simple terms, I'm not going to go into a huge amount of detail. We did run an IR35 event through the CIPD branch, and I believe that that event is up on our YouTube channel. So if you're still grappling around IR35, then you can have a look back at that. Myself and Helena from Birkett Long co-presented that on behalf of the branch. But in very simple terms, and for the purposes of this update, in both the public and the private sector now, we have a system whereby if you are other than a small employer, you engage an individual through an intermediary business, then you have to consider whether or not that individual, but for the intermediary, would be an employee of your end user business. And in those circumstances, you have to carry out a status assessment, pass that status assessment down the line, and ultimately that individual has to, the fee payer, which may or may not be the end user, has to deduct pay in a particular way so that a broadly equivalent amount of tax and national insurance contributions are paid. Again, another approach from HMRC to counter what was considered to be widespread avoidance or certainly minimising of tax through the use of an intermediary company. And as I say, that's a very gross simplification of the changes that have taken place. If you do want to find out more, as I say, there is the recording of the earlier event that myself and Helena had presented. So I promised only to be brief on furlough. Now, there is obviously lots and lots going on, and lots of different things to be keeping track of in terms of which businesses can open, when, how, you know, whether individuals are allowed into the premises, and so on and so forth. I'm just going to quickly look at where we are with the furlough scheme, and the key points are up there on the slides. We now have a situation where furlough is due to end on the 30th of September. I am not putting any money either way on whether or not the furlough scheme will end on the 30th of September. But we are currently in a position whereby the furlough scheme, which I'm sure you are all aware, allows employers and employees to agree that individuals will not work, and for the proportion that they are not working, they will be claimed under the furlough scheme and reimbursed for a proportion of their salary. That proportion currently is capped at 80%, or 2,500 per month, and it's proportionate to any working time, where the rate of pay has to be paid in full for the actual working time. You're going to bed? All right, because I'll come and see you when I'm finished, okay? Changed. All right, we've had your medicine, haven't you? Thank you, sweetheart. So that is the position, as it says on the screen as well. Employers are having to pay national insurance and pension contributions in addition to any working time that is payable. From tomorrow, we have a slight change in who is eligible for the furlough scheme. So individuals who were employed between the 20th of March and the 30th of October last year are currently eligible.
Good night.
Night, night, Freya. Off you go.
How's your presentation presentation going?
I think it's going well, but you're right in the middle of it, so off you go.
Oh, sorry.
That's okay. And from Saturday, so the 1st of May, individuals who have been employed by the business between the 20th of March and the 20th of March 2020 and the 2nd of March of this year are eligible to be furloughed. Now, you might say, why the 2nd of March? And the reason being, it's the day before the budget. Right, you're off to bed. Off you go. Night, night. I promise that's the last one. So we have a slight change, and the reason being is no doubt to give some more flexibility to businesses to be able to flex in terms of placing on furlough or not. Individuals who may have been recruited throughout through the pandemic, but obviously have not previously been able to be furloughed, and to enable some flexibility if we do go into further lockdowns or there are further restrictions. Now, I'm personally very surprised it took so long for that eligibility to shift. Thank you, Melissa. They're very nice in small doses. Someone's just said that my children are very cute. I am really surprised that the date didn't shift as quickly as I expected. I thought the eligibility would shift straight away, and it's taken, well, until Saturday for that to happen, albeit that it's been known for a little while. In terms of a shift for what we are able to claim as businesses, from the 1st of July, the contribution from the furlough scheme drops to 70%, with and capped, as you can see from the screen, £2,187.50 per month, and with the employer contributing the 10% to make it up to 80%. Again, with the caveat that any working time is to be paid in full, and those costs are met by the employer. We then have a shift again on the 1st of August, where the contribution under the furlough scheme drops to 60% and capped at 1,875. I haven't checked the maths, but I'm sure that all works out. And with the employer contributing 20% again to make it up to the 80. And with all the way through all of that, you've got the employer national insurance contributions and pension contributions to be paid. Now, it has been the case since December of last year, but I will just reiterate it, that under the furlough scheme now, it wasn't the case when the furlough scheme originally came in, but under the furlough scheme now, you cannot claim for employees who are under notice. Now, that's whether you have given notice as business or whether they have given notice to you. And it's also whether it's connected with redundancy or whatever the case may be. So if you do have an employee who is under notice, then you are not able to claim furlough for them. And that means in turn that you will have to fund the notice in full. Also, just worth noting that the notice pay should be paid at the full contractual rate rather than any reduced furlough rate. And again, that's been the case for some time. All right, so that's what I wanted to say on furlough to bring you up to date with the current position. A few other things in connection with the pandemic and some things that have sort of come out of the woodwork, if I can put it like that. Right to work checks, so the checks that you have to carry out before individuals commence work with you to ensure they have the right to work in the UK. There has been an adjusted procedure since the 30th of March of last year. And that adjusted procedure, which enables you to verify via copy documents or indeed on a video, that adjusted procedure is ending on the 16th of May. So from the 17th of May, we revert to the old position of having to see carry out right to work checks and having to see original documents. So if you have been using that, if you have been recruiting, and if you're continuing to recruit and grow, then you just need to be aware that those procedures are coming to an end, and we have to revert back to the old situation. There is also a slight change that we are expecting from the 31st of May. Draft legislation is anticipated to come in with effect from that date, and I'm sure many of you will have become all too familiar with Section 44 and Section 100 of the Employment Rights Act, which give protection to employees currently against detriment in the case of Section 44 and dismissal in the case of Section 100, where an individual raises concerns in effect or refuses to go to work or leaves work because they have concerns about health and safety. And as you can see, it's where they have a reasonable belief that either themselves or others are in serious or imminent danger. Now, that is expected to extend in the case of detriment only, so not dismissal, but detriment to workers. So not just employees, but workers. So that would include people in the gig economy, 0 hours and that sort of scenario. So do be aware of that. We will send out updates once we know that that is coming into effect. But as I say, we are expecting that to be in place from the 31st of May. Now, I've been asked a question in terms of whether or not you have to go back and check documents in relation to checks that have been carried out under the adjusted procedure. I did mean to check this before I came onto the presentation, and from memory, there is a procedure that you will need to go back through to verify, in effect, people that you have verified as having the right to work under the adjusted procedure. And I'm trying to recall off the top of my head what that is, but there's a form of wording that you have to use, and then you have to go back and you have to verify and say that it has been re-verified from memory. But I will double check that and send some details out via the Eventbrite once I've finished the presentation. Okay, so I haven't put it on the slides, but just to flag that we have what is a relatively infrequent recurring issue where we are expected to have an additional bank holiday in 2022 as the Queen celebrates her Platinum Jubilee. I'd urge you all to have a look and just think about the situation and how that affects your employees and your workers ahead of time, because you can always guarantee that employees will be thinking about these things. If you can get ahead of the game and explain to people what their position is, are they entitled to the additional day? Will they get paid? Do they have to take the additional day out of their holiday entitlement? All of that sort of thing. Just have a look at your contracts. They should hopefully explain whether it is they're entitled to all bank holidays under their contract to be paid, whether it's usual bank holidays. Some contracts will spell out the specifics of the bank holidays, so 8 bank holidays and actually which days there are, in which case they might have, those individuals would have to take that day if they want it as out of their other holiday entitlement. So as I say, do have a think about that. I believe it's the 3rd of June. So it's sensible to start to think about that and get ahead of the game. So final point just around sort of what's going on in the world of legislation and things like that is just to mention GDPR. Not much is changing and not much is likely to change. But we do have a situation whereby potentially data transfer to and from EU countries, which previously, prior to Brexit, would have been permitted because GDPR applied to all countries within the EU, is due to the bridging agreement from Brexit is due to come to an end on the 30th of June. Now, unless there is some sort of agreement which allows, sort of treats the UK as being of equal protection equivalent to the EU, then in theory that situation ends. Now, draft adequacy agreements were published for the UK, and we are very much hoping that those adequacy agreements will be in place before the 30th of June, so that as you can see from the screen, what's been described as frictionless transfer of data described by the ICO can continue, but we've just got to keep our eye on that and just sort of check the situation. Now, that's probably more of a concern for businesses where you might have overseas offices in the EU and so on and so forth. Just keep your eye on that and make sure that situation sort of plays out as we're expecting. Just very briefly on Brexit generally, I mean, again, I'm not expecting much to happen. I have high hopes of CIPD being looked at, very, very high hopes of holiday pay being reconsidered, but very low expectations that obviously very much is going to be done, and fully appreciate that there are probably bigger fish to be frying at the moment. But again, we'll sort of keep an eye on that and what transpires as things move forward. Okay, so this is probably one of the, I don't know, maybe the second or third update I've done in about a year where I've actually decided that I quite like to concentrate on case law for relatively obvious reasons. Now, there have been quite a few cases in recent months that are worthy of mention, and I'm going to jump around a little bit, and I'll deal with some of the ones that have received some of the sort of the media attention of late. Uber is an obvious one. I'm not going to spend a huge amount of time on Uber, purely and simply because it's a fairly fact-specific decision. Broadly speaking, Uber were arguing that their drivers who used the Uber app, they logged into the Uber app, they were offered the opportunity to transfer individuals from one place to the next, told which way to go, and told the fee to be charged. They were arguing that these individuals were self-employed and were not entitled to things like holiday pay. A number of Uber drivers challenged that decision. It's gone all the way up to the Supreme Court, and the Supreme Court has ultimately decided that these individuals were and are workers, and that is despite very careful, I choose my words again carefully, very careful drafting by solicitors to try and avoid that conclusion. So specifically, for example, the provisions in the contracts which said that they are not workers, they're not employees, etc., and sort of a very contrived approach to the contractual relationship. Ultimately, the Supreme Court has looked at what was happening on the ground, and they have determined, as I said, that Uber drivers are workers. Now, that has had a knock-on effect in terms of Uber. Uber were originally saying that this doesn't apply to all of our drivers because they all have different contracts. They have since resiled from that position and are now magnanimously, she says, tongue-in-cheek, saying that they are going to treat individuals, all of their drivers, as workers, and they will be paying holiday pay and so on to all of their drivers. Now, that has had a knock-on effect in terms of Deliveroo. There was due to be, or potentially going to be, an appeal up again, I think up to the Supreme Court in terms of Deliveroo riders. I think that's now, well, I think the court has said that they're not giving permission for that appeal to go forward. But if you do have individuals who you engage ostensibly on a self-employed basis, where actually you're at risk of them being considered workers or indeed employees, and this is where there isn't an intermediary company where IR35 might apply, then this is probably a decision for you to be thinking about, and it is certainly, just give me a second, H, certainly a move and an increasing move, in my view, towards a greater protection, rightly or wrongly, for individuals rather than sort of in the interests of business. What's the matter, sweetheart? Okay, can you go and get yourself a drink? Ask Alex to get you a drink, sweetie. You've got what, sorry? You've got a drink. Okay. Will you get yourself in bed and get yourself tucked in, and Mummy will come in? I'll come and sit with you, I promise. Okay, off you go. Okay, so as I say, it's just worth having a look at that if you do have that sort of situation, and just think about if there is an alternative approach. Because, I mean, broadly speaking, I think if they look like workers and they smell like workers, then the chances are they are, regardless of what contractual relationships might be in place. Another one that's been in the news of late is the case in relation to national minimum wage and sleep-in workers, mainly in the care industry, but sort of have ramifications across a range of industries where there are shifts and individuals have the ability to sleep whilst they are on shift. It's gone through again, this went all the way up to the Supreme Court, and the decision has come back in favour of the business in effect. So what the Supreme Court have said in very simplified terms is that for the purposes of the national minimum wage regulations and whether they are entitled to the national minimum wage for certain portions of a shift, what they have said is that individuals are only working for the purposes of the national minimum wage regulations where they are awake and where they are in effect attending to a duty as part of that shift, and not where they are sleeping. Now, I think, well, certainly businesses will be welcoming that decision, and it enables those businesses to revert back to what was an approach where there is an allowance for a shift, of a fixed amount, and then that allowance is topped up if the individual is in inverted commas called to action. Now I watched a presentation with the Queen's Counsel, who actually represented the individuals in the MenCap case, and I think he was ever so slightly disappointed at the decision. And this has gone round the houses, but this is now the definitive position in relation to sleep-in shifts, unless and until there is any change in the law. So if you're in that sort of industry where there is this sort of allowance ability and keeping an eye on national minimum wage for that purpose, as I say, this is the definitive position now, unless and until the government decides that there's going to be a change in the situation. The other case that has received sort of a little bit of press is the case at the top of the left hand side of the screen there, which is a case concerning shared parental leave pay. Now, I know that there is certainly anecdotally a very small uptake of shared parental leave, in the sense of one parent or one individual within the relationship opting to take maternity leave or adoption leave, and sharing that leave in effect with their partner. And since this idea came in, I can't remember when shared parental leave came in now, but since this idea came in, there has been this debate about whether or not the parent who is taking the shared parental leave is entitled to the same rate of pay as somebody who would be on maternity leave. There have been a few cases on this, and we arrived at a position whereby maternity leave was considered to be for a particular purpose of enabling, in the case of maternity leave in particular, the female partner to recover from childbirth, to build the relationship with the child, as well as to to provide childcare in a very, again, gross simplification approach. So Mr. Price, who worked for Powys County Council, came up with the clever idea of comparing himself to somebody who was on adoption leave, who, by the very nature of adoption leave, had not gone through the process of giving birth. And he tried to argue, and you'll know where the outcome was from what I've just said. He tried to argue that his position in terms of sharing parental leave was comparable to somebody who was taking adoption leave, so a female employee who was taking adoption leave, and accordingly that he was being treated unfavourably because of his sex. And as I say, that case was unsuccessful, and the tribunal drew again a comparison in terms of parental leave and adoption leave, and looked very carefully at the adoption regulations, in the sense that the primary carer, the person who elects to take adoption leave, in effect is stepping into, and I do appreciate this could be quite a delicate subject, and I apologise for talking about it in such a way, but in effect they are stepping into the shoes of a female individual who has given birth. They're electing to be the primary carer. They're able to start adoption leave from an earlier date, so that they can start to prepare for the adoption coming in the very same way as maternity leave can start earlier. And it's not just a case of the sort of recovering from giving birth, but adoption leave is a very similar approach in terms of enabling the relationship to build up, and as well as provide care to the baby, or indeed the more grown-up child in the case of adoption leave. And the court said in this particular instance to Mr. Price that whereas somebody on maternity leave, or in this case adoption leave, would be paid a higher rate of pay than he would be taking shared parental leave, he couldn't compare himself. They were two different purposes, and he was only entitled to be paid shared parental leave pay, so the statutory rate of pay, rather than any enhanced rate that was paid within the county council. Now, I think that should put pay to any further arguments or further challenge in the context of shared parental leave and pay, and attempts to guarantee or to argue that individuals should be paid the same rates as enhanced rates for maternity leave or adoption. We'll see whether or not that goes any further, but certainly again we are in this position where you can have a differentiation. You can have an enhanced rate for maternity and an enhanced rate for adoption, but a lower rate for the shared parental leave pay. Individuals who are taking that, and that's regardless of their sex. Now, moving on, I'll deal with two cases which have arisen through the pandemic, with the caveat that they are both employment tribunal cases, and therefore sort of indicative of how how employment tribunals might deal with these sorts of situations. So the first one that I'm going to talk about is just second from last on the slide there, and it's the case of Kubilius, and I'll just call it Kent Foods, I think. So in this particular instance, the individual was a truck driver and he worked for Kent Foods, and he was visiting, I think it was Tate and Lyle or something like that. He was visiting a third party site in his truck, and the third party site had a policy whereby anybody visiting the site had to wear a mask, and the individual refused. And so the business, Kent Foods, were in a situation of having to consider how to deal with this situation. The third party was saying, unless he's going to wear a mask, he cannot visit this site. The Kent Foods were in a situation where this particular site was the main site that their employees had to visit. They had an employee who was barred from attending this site, and they had to reach a decision as to what would happen. Kent Foods took the decision to dismiss the individual, and he challenged that decision in the employment tribunal, and the employment tribunal concluded that that dismissal was fair. The tribunal concluded that the business in effect was left with no alternative. There was nowhere else that he could be moved to. He was refusing to comply with a reasonable instruction to wear a mask, but admittedly by a third party. That third party was refusing to allow him on site, and the tribunal, as I say, concluded that that was a reasonable approach for Kent Foods to take. Now, it's a useful case, as I say, in the context of the pandemic, and considering how things might work in the context of individuals refusing to comply with arrangements in terms of health and safety to protect both the individual and also others who might be on site, whether they're third parties or your own employees. But it's also a useful reminder that sort of third party instructions, third party directives in terms of who may or may not be allowed into their premises, or who they would be prepared to engage with on their contracts, and how that can impact on a situation. So, as I say, just something that's worth raising and bearing in mind in the wider context. The other case that I just wanted to mention in the context of the pandemic is the Rogers and Leeds laser cutting case. Now, this was very, very early doors in the pandemic. Mr. Rogers, I think he was dismissed in April 2020. So very briefly, the scenario was that Mr. Rogers worked in a sort of large type of warehouse, fairly open. There was a sort of, I think, between 5 and 8 individuals within this particular space, and evidence was fairly vague but quite clear that everyone within this space was able to socially distance. The business had put in place, bearing in mind we were very early doors in the pandemic, they put in place hand sanitizers. There were wipes, etc., around for wiping down surfaces. So they'd done everything. The business had done everything that they needed to do to protect, within the context of what was known at that time, the situation for their employees, and in effect implement a COVID safe environment. Now, one of Mr. Rogers' colleagues had was suspected to have COVID. They went home, and I'm going to start to, everyone's starting to join now. So I'll just let these people join, and then I'll explain the situation. So Mr. Rogers had a colleague who was suspected to, I'm going to have loads of people join now. All right, I will just, what I'll do is I'll let more people join, and then I'll just do a brief explanation. So Mr. Rogers, as I say, I'll finish this case and then I'll do the explanation. Colleague suspected with COVID-19, they self-isolate, and then he develops a cough, he self-isolates, and but bizarrely broke self-isolation in order to take a friend to hospital who happened to be a colleague. And following that, he texted the company and said that he was going to stay away from the workplace until the lockdown, in quotes, eased. And he didn't return to work. The business later dismissed him around about a month later. He had less than 2 years service, and so was in a situation where he had to rely on the provisions that we were discussing a little bit earlier around serious and imminent danger, or a concern about serious or imminent danger under the Employment Rights Act, and the automatic unfair dismissal protection that gave him. Now, the Employment Tribunal looked at the circumstances and they said, well, actually, you didn't raise any concerns about the safety precautions that your employer had taken. You have given evidence, as indeed has the business, that COVID secure arrangements, such as they were in the early doors of the pandemic, were all in place. You were perfectly happy that the social distancing could take place, and nothing in what you had said to the business indicated that you were concerned that there was a health and safety concern within the workplace. And in those circumstances, we are not satisfied that your refusal to return to work was connected with the health and safety arrangements in the business, and that you genuinely, reasonably considered that there was a serious or imminent threat or danger to your health, or indeed the health of anybody else. And in those circumstances, it said that whilst it was quite critical, well, the case didn't actually go into the details of the dismissal, but it was very clearly took a fairly dim view on how the business had dealt with the dismissal in relation to Mr. Rogers in those circumstances. It was a specific hearing to consider whether or not there was an automatic unfair dismissal in connection with the health and safety arrangements. Okay, now I'm just going to do a brief, for people who have just joined, I have to apologise to you because I think, I'm going to turn the light on as well, there has been some confusion between Eventbrite and Zoom in terms of the start times, which has arisen from the switch across to British Summer Time, and we created the event pre-British Summer Time, and I think it's just caused a little bit of confusion. So if you have, those of you who have just joined, I am very sorry for that, and that you've not been able to get in, and I suspect some of you have probably had a frustrating hour or so trying to get in. The event has been recorded, and you will be able to access the recording on the YouTube channel, but I will also I'll edit the event straight away after we've finished tonight, and I'll get that sent out to you via Eventbrite, so you'll be able to have a look at that. But I am very sorry about the confusion. Going forward, I will make sure that the Zoom links are sent out to everybody through Eventbrite as well, so that, and I will make clear the actual time. I've done it for the next event. I've said that the event is starting, I think it's 1 o'clock, I can't remember now. I will make it clear in the invite that the particular start time. But I think you've struggled to get in as well through Eventbrite, so I'm not quite sure what the situation is there, but I do apologise. Okay, so there's going to be a few other people who will come in, and I'll just break to explain myself. So apologies to everyone who are here and listening merrily. So that's sort of the two cases around the health and safety in the context of the of the pandemic. Now, just need to see where we are in terms of what I haven't covered so far. So the fire and rehire case, I know this was covered in the Personnel Management magazine, and it's a Scottish case, an interim decision by the Scottish Court of Session. Now, I haven't been able to find a huge amount of detail on this, but I just wanted to flag it to the extent that I have been able to find some information. Now, this involves a particular location of Tesco's stores, and as best as I can tell, Tesco have a retention payment that has been paid to some of their staff over the years. It's a contractual arrangement, but is historic, and Tesco are wanting to phase this situation out. Now, the union have blocked it, and they do have a temporary order from the Scottish Court of Session, as I say, to prevent Tesco from dismissing the individuals at this particular site, and I believe it's Livingston. They have an injunction against Tesco to dismiss the staff, with the view to Tesco then offering a new contract to them to rehire them, but without this retained payment. And the loss to the individuals varies from, I think, between £4,000 and £14,000. Now, some of the headlines I've read, in my view, have been quite misleading, broadly suggesting that this is the nail in the coffin to the practice, certainly, of dismissing an individual from their current contract in order to rehire them on another one, which either includes inevitably less beneficial terms. That's not the case. This case isn't the nail in that particular approach. It is an interim decision, and as I say, I haven't been able to track down the decision to drill down into the detail. But as soon as I'm able to get that, then I will be having a look at it. But it's an interesting approach that's been taken by the union in this particular case, but it's certainly not a full stop to that approach, and it certainly does, in my view, remain a tool in the armour, albeit quite a dangerous one, for a business to say, we want to make this change to your contract, you're not agreeing to it, we've tried our very best to persuade you, you're not persuaded, but we really need to push this through, and therefore we are going to terminate your current contract, and we are going to offer to rehire you on another contract. For any employee who's got more than 2 years service, you run the risk of an unfair dismissal claim, and you have to have one of the fair reasons for dismissal. You would, in theory, have to terminate the existing contract in accordance with the terms of it, so give notice, etc., etc. Arguably, you would have to pay holiday pay in lieu or accrued but untaken holiday. And as I say, you wouldn't necessarily be guaranteed that the individual is going to accept the contract that you are offering. So that's the fire and rehire case. Now the next two cases sit quite nicely together. So they're the bottom of the left-hand side and the top of the right. So the first case is, for me, quite an interesting one, and it involved a situation, two cleaners working in Pure Gym, employed by a third company. Now they have a practice within the business where there is a handover book, as you might expect, and as part of a handover, a manager at Pure Gym mentioned that there were three individuals messing around, and we're not quite clear. I'm not quite clear from the decision what particular words were used by the manager to the cleaner, but the cleaner made a note in the handover book describing these individuals in what I won't use the word because I don't want to offend anyone, but in what could be considered to be an outdated way to describe somebody, and of an ethnic origin. And the second cleaner saw this particular note in the handover book, and what is clear is, whilst he was upset at the use of this outdated phraseology and actually made an annotation to correct it, he took the view that it was an outdated phrase that was being used, and that actually what he wanted to do was to talk to the colleague who had used this phrase and, in inverted commas, educate them. So whilst he was upset, he wasn't terribly upset. So we fast forward a few days, and the point in time at which the two individuals are next on shift, and Mr. Justin, who is the individual who was upset, approached his colleague. Well, I think it was the other way around, actually. His colleague approached Mr. Justin. Mr. Justin had not long started, and his colleague asked, whether they were going to do a particular type of training that evening as part of the role. And Mr. Justin was quite abrupt and sort of basically said no. So the conversation got off on completely the wrong foot and deteriorated quite rapidly. Conversation took a matter of minutes. Mr. Justin sort of tried to correct the particular individual. The individual by this time was quite upset at how things had developed and not quite sure what was going on, felt that Mr. Justin was being quite aggressive towards him, in turn became quite defensive and tried to explain himself in terms of why he'd used this particular terminology, in effect adopting the position that Mr. Justin had anticipated. This particular chap was older, and we all know that the particular phrases have been acceptable and moved into no longer being acceptable. And in effect, he was explaining his position in much the same way that Mr. Justin was wanting to correct him. So Mr. Justin left his employment. He resigned, and the question was, he brought a claim later that he had been harassed by this situation, and the employment tribunal considered whether that was the case. Now, it's important to understand the case wasn't phrased on the basis that the use of the outdated phrase was harassment by itself. What Mr. Justin argued was that it was the way in which his colleague tried to defend the use of the phrase. So it wasn't the initial use of it. And in fact, the tribunal found that it was, you know, his colleague was actually doing his best not to offend anybody, because he felt this particular phraseology was better than any other phraseology that might have been used, or he might otherwise have used himself. And so they said there was no intent in the sense of harassment from a legal perspective. There was no intent by this colleague to harass anybody. And equally, Mr. Justin wasn't offended at the point in time at which he read it. He understood that, you know, this was sort of a situation where there was a need for education. Mr. Justin was saying, as I say, that it was the response of his colleague in defending himself that was the act of harassment. Now, the tribunal basically said the conversation got off on the wrong foot. The conversation deteriorated at a rate of knots, and his colleague wasn't being harassing. You know, there was no intent there. There was no actual offence. Mr. Justin, whilst he was trying to portray himself as being offended, and may well have been offended, actually that wasn't a reasonable approach for Mr. Justin to take. And it's important to remember that, and this is really the crux of why I wanted to raise this particular case. You can have situations where individuals are using words that are overtly, if I can put it like that, of a racial nature or of a sexist nature, and have potential to offend or to cause an offensive environment, and so on and so forth. And this is one of those potential situations. But because of Mr. Justin's initial reaction, and then because of the approach of the colleague in kind of supporting that initial reaction, the tribunal said there was no harassment. So it is really important, and I've been discussing actually with a number of colleagues in recent months. It's really important to put the situation into context for the purposes of harassment, and actually to look at how individuals react to it, and whether they are apparently upset at the time, offended in the words of the language, or whether it's something that they are retrospectively trying to create. And in effect, that's what the tribunal determined Mr. Justin in this particular instance was trying to do. He was trying to turn a situation into you know, something that it wasn't at the time. Now, the follow-on, the LA case sort of follows on from that, in the sense of the circumstances in which an employer can avoid liability. So if we reverse to the Pure Gym situation, you know, the ability of the employer to avoid liability had that decision been decided in another way, for the actions of that colleague in upsetting, harassing Mr. Justin. Now, over the years, again, I've been involved in a number of cases, and we've put this argument forward. Thankfully, never had to call upon it. But employers can avoid liability for the actions of their employees in terms of discrimination if they can demonstrate that they have taken reasonable steps to avoid the discrimination taking place. Now, in this particular case, there was a individual, Mr. Gellan, of Indian, in the words of the decision, Indian origin. And the case found that there had been quite regular comments made to Mr. Gellan in relation to his Indian origin, racial, you know, his racial background. Again, I won't give you details of it because I don't want to offend anybody. And the company attempted to argue that because the individuals involved had been through equal opportunities training, they had been through bullying and harassment training. There was an equal opportunities policy, there was a bullying and harassment policy in place. They argued that they had taken reasonable steps to avoid this type of behaviour taking place, and therefore, if there was any liability, it shouldn't rest with the business, it should rest elsewhere. Now, the tribunal looked at this and they said, okay, yep, this training's taken place, and it taken place, I think, something like 18 months to 2 years before Mr. Gellan, he was dismissed, and he raised this issue post dismissal. You know, they looked at it and they said, okay, well, yes, you've had this training, etc., but ultimately, in effect, it wasn't effective. Now, that isn't in and of itself a key in the decision, but one of the other aspects was that there were 2 managers who the tribunal found were aware of the behaviour that was going on, but didn't take any action. These 2 individuals had been through the same training as the colleague who was the offender, if I can put it like that. And ultimately, what the tribunal said is that the training that had been put in place, the steps that had been taken by the business, had become stale, and it would have been a reasonable step for the business to refresh that training. Now, I know that I'm sure a lot of you will have great equal opportunities policies, you will have great bullying and harassment policies, and you might actually have no concern at all within the business as to whether or not behaviour that might fall foul of these policies is ongoing. Now, if you want to be in a safe, in inverted commas, position to avoid liability for the actions of your employees going rogue, if I can put it like that, then you need to make sure that you are reminding individuals of these policies and that you are refreshing training, so that you can call on the records to evidence that last week such and such received training on this, that and the other, and this is the contents of the training, and they were very clearly told that the behaviour that they've engaged with was not appropriate and that they would be at risk. Now, it doesn't mean, you know, you don't have to do everything to physically stop people, you don't have to supervise people 24/7 and, you know, physically restrain them from doing things. But if you have put the training in place, you're refreshing it, you're reminding people about the arrangements that exist, the fact that they risk being disciplined and dismissed, then the chances are the tribunal will look at it and go, you've done all you can. You can't physically stop people from, inverted commas, going rogue, but we're satisfied you've taken reasonable steps, and therefore you as a business are not liable for the actions of this particular individual. So, I mean, I think it's all the more important to flag this, as some of you may well be going through a situation of bringing individuals back into the workplace who perhaps haven't been in the workplace or indeed working for a considerable period of time. And I anticipate some of you may well be thinking about a kind of quasi reinduction process, and it's worth thinking about this case as part of that. It is you know, it's something that you can build into that particular situation. Sorry, I'm just reading I think I've managed to upset somebody by trying not to upset anyone. I sincerely apologise that is the case. It's always difficult to talk about these cases in a way that doesn't upset people. So I am very sorry that I have done that. Okay, so we move on from those two cases around harassment and discrimination and sort of protections that exist in relation to that, and I will finish on my favourite topic of holiday pay. Very briefly, I'm pleased to say, the Pimlico case, I'm sure many of you will be familiar with in the context of worker status, and touching on the Uber case that we have we've briefly spoken about. This particular case, it is the same Pimlico case. It involves the situation where somebody was considered not to be a worker for a period of time. They took holidays. They weren't paid holiday pay, as they weren't considered to be entitled to it, and ultimately their engagement came to an end, and they brought a claim trying to claim back holiday pay for all of the holiday that they had taken, and which they hadn't been paid for. Now, Mr. Smith, unfortunately, as it transpires in this particular case, missed the boat, so to speak. So the last instance of holiday he took, and for which he was not paid, took place more than 3 months before, I can't remember what the dates are, but more than 3 months before he had to raise a conciliation through ACAS and or bring his claim. So the question for the tribunal was whether or not he had brought his claim in sufficient time that he could claim the back pay. As I say, for Mr. Smith, he missed the boat because he was more than 3 months after the last occurrence on which he took holiday but was not paid for it. So in the particular case of Smith, he was only allowed to claim for accrued but untaken holiday for the current holiday year. Now, many of you may remember me talking about the case of King and Sash Windows a little while ago, where an individual worked for this particular company. They hadn't actually taken holiday, and at the end of their engagement, they brought a claim for all of the backdated holiday, and they were successful. Now, the difference between that case and the Smith case is that Smith had taken his holiday but not been paid it. In the King case, he hadn't taken his holiday, and obviously he hadn't been paid it either. So it's just a sort of fine, for me, it's quite a fine line, but it's an important reiteration for individuals in particular to be mindful of the limitation date, but from an employer's perspective, to check the limitation dates and to actually challenge the position if you think that a claim has been brought out of time. Now, as I say, Smith got past the post so far as accrued but untaken holiday on termination, but not so far as being able to go back. Now, in current terms, a claim for backdated holiday pay is you can only go back 2 years. And I did see a headline somewhere suggesting that Smith's claim was worth something in the region of 74,000. So he must have brought his claim before, and on the basis of, you know, the path through the various tribunals, he must have brought his claim well before that restriction came in. So that's what I wanted to say around the case law. Now, just very briefly looking forward before I come on to any questions, we just wanted to quickly look forward to things that might be coming in the future. We are overdue the employment bill, which is anticipated to include the ability to apply for flexible working for everyone. protections around redundancy for individuals who are pregnant or returning from leave in that context, carers leave, and also neonatal leave. Now, I know Channel 4, I think it is, have been in the news recently for their sort of policy around giving leave for parents who are in the unfortunate situation of losing individuals, losing babies during pregnancy. So it will be interesting to see how these things pan out. I was watching a presentation last night which suggested that the employment bill is anticipated to come in by the end of this year, but again, I don't know. There are some consultations that have recently closed around non-compete clauses and also exclusivity clauses in the likes of 0-hour contracts and that type of thing. Again, we'll have to wait and see when time allows as to which direction these sorts of things go. Ethnicity pay gap reporting, we were expecting that to come in, but there was a report issued earlier this month which suggests that ethnicity pay gap reporting isn't going to be mandatory, but is going to be voluntary. So again, we will just have to wait and see what happens there. Very quickly, we've got some upcoming events. We've got HR issues and the return to the workplace that I've mentioned a couple of times today. It is the 17th of May, so you'll find details on the CIPD Essex and Ipswich Eventbrite page. And also we have our annual meeting coming up. We haven't yet published this, but it's on the 26th of May. It will be on the 26th of May. From memory, starting at 4 o'clock, and we are combining that with an event on how to become a strategic thinker. So do watch out for the details on that. And my eldest is now coming in. No, she's not. Hello.
We can't get to sleep.
Okay, I'm nearly
snoring.
Okay, well, okay. Do you want to go and sleep in Mummy and Daddy's bedroom? Okay, good girls. One of my children's not been well and is snoring. So we've also on the slides there, we've got some upcoming CIPD events from head office. We've got the Festival of Work coming up, the annual conference and exhibition, Wellbeing at Work, etc. So please do have a look at those. We've got a survey open on future events, so please do fill that in. It really won't take you long, and also a survey, if you wouldn't mind, on this event as well. I'll post those two links into the chat very quickly whilst I remember. And where have I gone? If you would like a copy of the notes, then please do just get in touch with me and I will very happily send them across to you. So finally, I think, hopefully, yeah, we've got my contact details there, and I will just quickly look through and see. I noticed there was a question about the 2-year period for holiday pay and which regulations, and I can't remember that off the top of my head, but I will dig that out. So it's the 2-year. There was another question that I was going to send the details through of. Oh, it was the right to work checks, wasn't it? Right to work checks, and also the 250 UK. So let me just see if there are any other questions. So. Okay, I can't see any other questions, but if anyone's got any questions, if they want to just unmute themselves, that might be the easiest approach for us to take. I'm going to stop sharing the screen, and if you want to pop your video on and pop your voice on, unmute yourself. I'm very happy to take questions that way. Otherwise, if you prefer not to and you want to just pop the questions in the chat, then please do. I'll give it a few minutes. If there aren't any questions, then I'll close things down. And as I say, please do complete the survey. Do have a look at the events that we've got going on, both within the branch and the wider CIPD. We'd love to have you along.
Can you close the window in your room?
Okay, I'm very nearly finished. Okay. All right.
How long until you're finished?
Not very long at all. All right. I'll be in a minute. All right. Okay, so I'll do the recording as soon as I can after this. I'll just make sure all my children are okay. I'll send out the recording via Eventbrite. What I'll do is I'll upload the notes to WeTransfer as well, and you can download them that way. The link will only last for 7 days, so do make sure that you can do that. Otherwise, just get in touch with me on the email and I will pop those across to you in hard copy as well. All right, well, I don't think I've had any questions, which is, I don't know whether that's a good or a bad sign, but I'll take it as a good sign. So it leaves me to thank you all for your attendance. I do apologise for the confusion around the start times and for any offence that I have inadvertently managed to cause. Please do check out the events, and it leaves for me to say good night.
Thank you, Julie. Thank you. Thank you, Julie.